Okay. So we only have one case on the docket to be heard this morning, and that it's a consolidated appeal. Schultz, Favreau, and Graybow, is that how you pronounce it? Versus Durrani. How much time would you like to reserve?
Your Honor, my understanding is this is a 20-minute argument. I'd like to reserve 5 minutes for rebuttal.
Okay, thank you. Give me just a second to get my uh timer up. All right, whenever you're ready.
Thank you, Your Honor. Aaron Herzig for appellants. May it please the court. I'd like to deal with two things today. Many of the issues that we've raised on appeal are issues that this court has decided. We obviously disagree with those and preserve those for other appeals, but they're not novel in this case. The two things that I think are important and worth talking about today are one, the joinder of three plaintiffs in one trial. This is only the second of what it will be many three plaintiff trials that this court will hear about. And two, in the case regarding Mr. Schultz, there was a doctor who, not Dr. Durrani, a general surgeon who helped with the procedure, who nicked an artery, and we were denied important protective jury instructions regarding superseding cause and regarding something called the captain of the ship doctrine. Appellees did not respond to either of our arguments there, so we think this court has to enter judgment for us and reverse, at least as to Mr. Schultz. So let me start with joint trials, if I may. And Judge Bach, I think we start with your concurrence in Courtney and Coblin. That's the right law. And I think it's undisputed. This remains the only county in the United States that we can find, that the court can find, that plaintiffs can find, in which medical malpractice cases are consolidated for trial. We have never specifically argued that there is no circumstance in which a medical malpractice case could be consolidated. Perhaps there are, but the consolidations that are happening here are unlike anything you see anywhere else. We think they are creating a great danger of unfair prejudice, and this case is a great example. We now have a three plaintiff trial, three people bringing evidence of their claims as to Dr. Durrani. Two-thirds of the evidence in the case has nothing to do with the other plaintiffs. It is a classic 404B problem, as Judge Bach pointed out in her concurrence, which I think explains clearly the danger of all this. We are fairly far down a slippery slope with no limiting principle from this court at this point. Nothing to stop you from seeing 4 and 5 and 10 plaintiff cases going forward. Let's talk specifically about
Counsel, if I may, did your research reveal any similar situations where you had a physician performing similar procedures on multiple patients, resulting in numerous claims?
So, Your Honor, the only cases we've ever found are the Ciuta case here in Hamilton County back in the 90s, and these cases. And you bring up a good point. That's part of the problem here, right? Think about a colonoscopy, a preventive procedure that every adult over 45 is now supposed to have by government recommendation. Our insurance companies want us to do that. Same procedure, same instruments, same part of the body, every single time. So what's to stop? And of course, there are always some negative outcomes. No surgery is perfect. There are thousands of these performed every year. There will be negative outcomes. Plaintiff's lawyer advertises, had a bad colonoscopy, give me a call. They then pull all of those colonoscopies together against various doctors, it's fairly easy to identify, and bring them as one case or a series of consolidated cases. Under this court's law, that is perfectly appropriate because it's the same surgery, the same place of the body, the same part of the body, and the same potential negative outcome, which is it didn't go well. And that's all you would need. The same is true for all kinds of things. Heart stents, very common procedure now. They happen thousands of times a year in Ohio and certainly hundreds of times a year in Hamilton County. Same part of the body, same procedure, same instruments, same implants. There is no limiting principle for those types of situations.
Mr. Herzig,
yeah.
obviously you know what I think about this, but you also know that I find it very important to follow this court's precedent. how could we get around what Jones says?
Your Honor, I think you read Jones a little too broadly. Jones started with the principle that, hey, these are two surgeries of two relatively similar people in the same location. We disagree with that, but we think it was a fairly narrow holding. It has expanded over time. The Haggard case that came out on Wednesday seems to say, well, anything goes. Just to be candid, when you're talking about whether there was conservative treatment or not, things like that, and those suddenly become the factors, whether there was back pain in general is part of what Haggard says. Every back surgery that I could possibly contemplate, of course, results from the fact that there was back pain. So first, Your Honor, I think you were giving Jones too much credit. Second, Jones cannot overcome the rules of evidence, 404B and 403. You have to look at those things and weigh them here. So I think every case has to be taken individually and separately. I don't think you had to say that Courtley and Coberlin had to follow Jones, or that Haggard did, or that any of the other cases do. Importantly here, that was a two plaintiff case. This is a three plaintiff case. It cannot be that Jones and Conley mean that you can do 100 cases. So I think you have distinguishing factors there. And look particularly at these surgeries. Like I said, perhaps there were similarities. We disagree with them, but okay, we see where the court is going there. Grabow, a 69-year-old man, went from an 8 out of 10 pain before the surgery to a 2 out of 10 pain after the surgery, was building a rock wall a year after the surgery and moving 2 tons of gravel. Dr. Bloomfield, one of the experts, left the trial before he testified for Dr. Grabow and declined the invitation to testify by Zoom. So different experts for Mr. Grabow. Mr. Schultz. Mr. Schultz has what's called an axial-lift, which is intended to be a minimally invasive form of surgery. Dr. Durrani asks Dr. Schneeberger, a general surgeon, to start the surgery to get him into the position where he can do the back part of the surgery. All the experts in this case agree that that actually exceeds the standard of care. Dr. Durrani could have done it himself. Dr. Schneeberger does it. Dr. Schneeberger nicks an artery of Mr. Schultz. Mr. Schultz has to get 14 units of blood, has all kinds of other complications with his surgery. And of course, there is this question of superseding negligence that breaks the chain of causation as to Dr. Durrani. Incredibly different from Mr. Grabow's outcome. Mr. Favaron, also Grabow 1 surgery at L3 to S1, Mr. Schultz 2 surgeries, L5 to S1 and L4, L5. Mr. Favaron, 3 surgeries. So three different numbers of surgeries for 3 different people. He had C4, C5, T11 and 12, L2, S1. 3 different parts of the back for 3 different people in 3 different numbers of surgeries. Mr. Favaron attempted suicide, allegedly because of his pain, at the age of 30, and dies of a heart attack several months later. The jury got to hear about that as to Mr. Schultz and Mr. Grabow. And Mr. Grabow and Mr. Favaron got to benefit from the fact that Mr. Schultz had testimony about having an artery nicked and the terrible outcome that that might have caused by another doctor. These cases are incredibly dissimilar. There is no case in which you would, and the other thing I would say, Your Honor, is to getting around Jones or limiting Jones to its particular facts, is you have Hounshill and Stevenson that talk about the 404B evidence and the danger that comes in from other cases. So Hounshill and Stevenson, are you having trouble hearing me, Your Honor? Nope, I think Judge Bach froze. Anybody mind if I pause for a moment? Judge Bach, are you back?
Yeah, I am. I don't know what happened.
Okay.
It just kind of glitched, but yes, I'm back.
Okay. What I was saying was that the other thing with Jones and Connolly is you have Hounshill and Stevenson that you can go back to in terms of the 404B evidence. And here is a great example of that. Consolidation cannot simply be an end around those rules. So you can rely on plenty of case law in Ohio and in this court to do that. And then let's look at what plaintiffs and the court said. Oh, by the way, in case you had any questions, there were specific objections made multiple times as to prejudice. It's at in the motion in limine at pages 43 and 47, which is transcript of docket 113, and at the beginning of trial, volume 1 of the trial of proceedings at 36 to 41. No doubt that there were clear, specific objections as to prejudice in each of these cases. So you have incredibly different plaintiffs with incredibly different outcomes. And what does the court say? Well, this will be easier. The economy is what rules the day. That isn't part of the Rule 42 analysis, and it certainly doesn't comport with due process or the purposes of consolidation. You don't just say, yes, this will be easier. The common facts he talks about are the alleged misrepresentations that Mr. Durrani may have made, and the fact that there were questions about whether there was conservative care or not. Again, those things, if that's the baseline, if that's all this court will believe, do I need to wait for Mr. Statman or shall I continue?
You can continue.
Okay. If that's the baseline for this court, there is no limiting principle to these cases. Let me move on briefly to the issue in Mr. Schultz's case with regard to the superseding cause. Two things occurred. Dr. Wilkie, in his testimony for Mr. Schultz, talks about something called the captain of the ship doctrine, in which basically the doctor who is the lead on the surgical team is responsible for everything that happens by other physicians in the operating room. Ohio does not follow the captain of the ship doctrine. Trial counsel asked for an instruction that said so. The trial court denied that. Obviously, too, that means there is potentially a superseding cause that broke the chain of causation between Dr. Durrani and Mr. Schneeberger, Dr. Schneeberger for Mr. Schultz. Trial counsel asked for that instruction and was denied too.
Mr. Herzig,
yes.
How many times did he actually say captain of the ship?
I know it comes up in I don't know how many times, but he talks about it in volume 4. Page 291 is where you can find that testimony. And I think, Your Honor, if we're going to be counting up how many times an error occurred where we asked for a specific jury instruction and that was denied, I think that would be the wrong standard, because then you're already jumping to harmlessness when clearly we should have had an instruction that said Ohio law does not follow this. So even introducing it, we think, is an error and unfair prejudice, whether he said it once or 10 times.
Well, I guess what I'm getting to is, like, if there was instruction, the jury might have placed more emphasis on the whole captain of the ship idea. It's something that seems like it's not a theme or a theory. It seems like it's something that is mentioned once or twice briefly and probably would not be in the mind of the jury unless it was maybe revisited in the jury instructions.
I think, Your Honor, that would be if we hadn't asked for the instruction below, fair enough, then you might have that. But here, trial counsel specifically asked for it. It is consistent with Ohio law, and it isn't the trial court's job or this court's job to guess at whether that was the right strategy or not, which is what you're talking about is, hey, maybe you would have been better off if you didn't ask for it. Your Honor, I don't think that's what this court should be about. We asked for an instruction that complies with Ohio law to deal with a specific topic that was raised by plaintiffs, and maybe that would have been a bad strategic call, but we'll never know. And it would be defendant's choice in this case to make that strategic call.
Was it an instruction that you all drafted, or was it something that existed in OJI?
I can look back, but I'm fairly certain it is an OJI instruction.
And counsel, besides the need for additional blood, what other harm resulted from nicking of the artery?
I think first of all, the jury gets to hear that something very wrong happened in the surgery that is not attributable to Dr. Durrani, but it piles on with Dr. Durrani. And there's other complications with recovery at that point, right? It's not just that you get extra blood, it's that you have a longer recovery, you had a longer surgery. It's the kind of thing that I think doctors take very seriously. And so I think there were a number of other injuries that occurred there.
Was there any evidence of a permanent injury as a result?
Not that I can think of off the top of my head, Your Honor. But I can, again, I'm not sure where that would fit in here, where we're talking about the question of, was that a superseding cause of the bad outcome here, the malpractice that's alleged. You'd have to tease out, and I don't know that anyone could, what his pain comes from in the future. That seems an awfully fine tool for this court to try to use in a three plaintiff trial where the entire intention of it was to pile on lots of extraneous evidence. And again, even as to Mr. Schultz, how does that, and I know I'm going back to joint trial, which is what I had moved on from, how does that have anything to do with Mr. Favron or Mr. Grayboe? But we think
Mr. Herzig, you have 5 minutes left if you want to reserve. Mr. Statman, whenever you're ready.
Can you hear me now?
Yes.
I'm sorry. I thought when you said 5 minutes left, he still had 5 minutes. I'd like to start by saying, quoting Emerson, Lake and Palmer, "Welcome back, my friends, to the show that never ends." So here we are, and I think we can start this by saying, completely reset and ignore everything you just heard. Now, why do I say that? I say that because the malpractice alleged in this case is not that Dr. Durrani did something wrong in the surgery itself. It's that these people were tricked into having surgery.
But wasn't there substantial testimony that the surgeries were performed incorrectly?
Well, there's testimony about the surgeries not being proper for the condition because they never should have had surgery in the first place. And if the malpractice is putting them through a medically unnecessary surgery, which is our cause of action in terms of negligence in this case, then all of this talk about superseding and intervening and comparative negligence, it all goes out the window. The defense's arguments have nothing to do with the plaintiff's claims. It doesn't matter. They should have never been on the operating table and exposed to the problems in the first place. So that does away with all these ideas of superseding and intervening cause. And I noticed that the appellant did not argue about comparative negligence. And one of those reasons is it's not in any of these cases. The fact that somebody exacerbates their back pain before they saw Dr. Durrani does not make them comparatively negligent. We're comparing the negligence of Dr. Durrani, which is to put them through an unnecessary surgery. Then they're saying, this is the appellant's argument. Well, you had the surgery, and now it's your fault you didn't get better because you did things you shouldn't have done before or after the surgery. That is nonsensical when the claimed wrongful act is putting them through the surgery.
Now, counsel, let me ask, did you address the issues of intervening and superseding cause instruction in your briefing?
No, they were not addressed. They don't even apply.
Okay, but do you think it's fair for you to be able to argue that now?
I think we can. It's
But it
in the
wasn't in the
brief. They've argued it. I can rebut it.
But you had the opportunity to do that in your brief and you chose not to.
But I also have the opportunity to rebut things in oral argument that are and aren't in the brief. I can tell you for a fact, 50% of my time in the Durrani litigation is rebutting things that didn't happen at the trial and aren't in the appellant's briefs. And they bring them up, including the fact that they believed in one argument that Pakistan was in the Middle East and I'm a racist, when Pakistan is in East Asia, and the trial judge has repeatedly said
That wasn't an issue in this case, though.
What's that?
That was not an issue in this case.
No, but I'm saying this
Okay, then
goes
skip
on.
it. Move on.
Multiple trials. Judge Barrett in federal court conducts 6 at a time, 3 at a time. no less than 3 at a time. He does have one coming up scheduled for 2. So 2, 3, and 6. So when counsel told you they're unaware of anywhere else in the country, their own trial counsel have participated in a federal court case with 3 and a federal court case with 6. Additionally, this same law firm just moved to consolidate the Dr. Saul cases into a singular case with 347 malpractice cases. So when the police says this is unheard of, it's not unheard of because their law firm is doing it themselves. So Judge Reese goes to great lengths to make sure that all of the cases are kept separately by the jury. There are 3 notebooks. They go all the way through the testimony of each witness on each case, and then start the next case with the witness. And this goes all the way through the trial. Additionally, in terms of arguments that have been made repeatedly before this court, one of the favorites of the appellee is, look, Judge, they're making all the punitive damage awards exactly the same. Well, this court has not been fooled by that in the past. But to counter their own argument, in these cases, the punitive damage awards were all different. All which says that they're looking at the conduct of Dr. Durrani on a case-by-case basis. The compensatory damages in this cases are all different, which means they must have looked at the harm done individually to each of the plaintiffs. So this idea that somehow this is causing massive problems and massive confusion just doesn't really bear out. Even in the 6-person case in federal court, the defense won 1 of the 6. They often win a case, or all the cases, when they're tried together. I think they win about 20% of the time in the consolidated cases, so that those cases are clearly not prejudiced. They're not coming in and saying, well, even the cases we win shouldn't be done that way. They win those cases. And so we have a clear history and a clear set of rules that the court has laid out now through, I don't know, more than 10 opinions, I believe. Well, I know it's more than 10, because where you have reversed 12 times, 12 cases, not 12 times, I have retried all 12 cases, and you can take judicial notice of the files in those cases, and I have prevailed without this alleged highly prejudicial evidence that gets excluded 11 of the 12 times. Juries are not confused by group trials. Additionally, it will not serve the ends of justice. This has been going on 13 years. If we are now going to finish one case at a time, there are 200 plus Durrani cases still to be tried, and that would take about 15 years at the current pace if we did them one at a time. 13 children's hospital cases that are yet to be tried that are currently set throughout 2026. So you're talking about people involved with Dr. Durrani having justice delayed, whatever justice is, whether that's a verdict for Dr. Durrani or for the plaintiffs, in a set of cases that will take more than 20 years if you don't continue doing group trials. The fact that you don't find them is you don't typically find a surgeon operating on 600 patients a year, seeing 2,000 patients a year, making similar diagnoses for all of his patients, and doing a series of similar operations. They may have different names, but they're all some type of spinal reconstruction, spinal fusion, disectomies, laminectomies. And so these examples they give you about, we'll go find 7 doctors that did gastrointestinal procedures with 7 different plaintiffs. Well, no, they would have to find a single doctor who was doing unnecessary colonoscopies and telling people that they better have the colonoscopy because they have polyps that they don't have, or cancer that were polyps and not cancer. That example you were given flat out fails. This is a circumstance. You know what? It's a good thing we don't see other cases like this. How many Dr. Duranis do we need across the United States? How many do we need? We don't. And this is a circumstance, just like in the case you decided in the 90s, that calls out for group trials. This one, even more. My recollection is that was 7 or 8. We started out with 450 plaintiffs. We're now down to 200 13 years later. 13 years. And we still have 200 to go. And that's not counting the ones in federal court. There are still cases pending in federal court, and that's not including the children's hospital cases. There is no other way to do this. And the evidence, not only from the appellate practice, but from the trial courts, clearly shows no prejudice to Dr. Durrani. None whatsoever. The verdicts are different. They're mixed. The numbers are different. Plaintiffs win. Defendants win. There's a mix in every case. Sometimes plaintiffs win 1, they win 2. Sometimes plaintiffs win 2, they win 1. All in the same case. All in the same consolidated case. And that defeats their argument. Because if it was really...
Mr. Statman?
Yes.
I have a question about the superseding intervening cause. It seems like the Schultz case might be a little bit unique in the sense that it does seem to be this complication that could be characterized as fairly dire, that put him in a fairly dire circumstance. Have any of the other cases had that sort of situation where there was a request for a superseding intervening cause instruction where there was another physician involved that was directly involved with a complication that gave rise to at least some of the damages?
Dr. Durrani has had an employee spine surgeon that worked as his assistant in some of the cases. That assistant carried out the surgery at the direction of Dr. Durrani. It was determined that since the surgery plan and the fact that Dr. Durrani was the primary surgeon and his associate was the secondary surgeon, that even though Dr. Durrani didn't do the surgery at the point in time some alleged problem came up, that didn't matter. But the plaintiff goes to the jury on the concept that these surgeries are medically not indicated, so that if you are a victim of an unindicated surgery put forth by Dr. Durrani, whatever happens in that operating room should have never happened because you should have never been there in the first place. So it's not, you can put this captain of the ship idea aside for a second because the ship should have never set sail.
Well, so I get that. I mean, I hear what you're saying about the captain of the ship and that he was in charge, which perhaps goes to their requested instruction. I'm just wondering if any of the other cases had anything like this, where it seems like a pretty dire complication that this individual suffered.
I think that there have been, I believe there has been one other bowel nick in one of the cases. I don't remember the outcome. There was a complication related to bleeding that put someone in intensive care for a period of time. I don't remember the name of that plaintiff. Unfortunately, it's really hard for me to remember 450 different plaintiffs' exact claims. But I do remember we had a series of intensive care visits, stay with one patient. There have been some other complications. The main complications usually occur from Dr. Durrani or someone from Dr. Durrani's staff. There have only been a couple, maybe a few, I'll go maybe 3, where it's an approach surgeon that nicks something or disrupts something that was during the approach or when they were closing after the surgery. But Dr. Durrani uses an approach surgeon as a regular method to get to the operating site. So Schneeberger and the like are regular characters in the cast of operating characters in almost every trial. That
Are they employed or associated with Durrani or his corporation? Are they separate?
No, they are separate individual physicians.
I mean, theoretically, they have to follow their own standard. I mean, they're not subject to his being the captain of the ship, for lack of a better term, right? They've got their own standard of care that they have to follow. They're not under his direction.
Well, they're only under his direction to give Dr. Durrani access to the surgical site without Dr. Durrani having to do the dissection. He's the one that brings them in. He's the one that tells them where he wants to get to. And they're the supposed expert at dissecting out the veins and arteries and the various organs to make sure that Dr. Durrani can visualize with his instruments the surgical site. But again, if the patient was never supposed to be in the situation, it is not a superseding cause. You cannot now blame someone for doing something in an operation a patient should have never had. That's just a philosophical concept of logic besides it being the law. If I kidnap you and drop you in the jungle and you get eaten by a tiger because the tiger handler wasn't properly taking care of the tiger, it doesn't matter what the tiger handler did. I dropped you into the jungle and you should have never been in the jungle. That's my problem. And that's what you've got here. These people were put on an operating table without proper informed consent, and they were then subjected to an unnecessary surgery that did them harm, not good. And there were other factors that came into play. Those factors would have never happened had Dr. Durrani followed the standard of care and realized it was a medically unnecessary surgery. We're all the way back outside of the operating room in this case.
So in the case of well, maybe in all of these cases, does the jury interrogatory specify, or does it anyway say anything about the cause of the injury?
It tells you. It's asked, what is your basis for the medical malpractice? When they check yes, the standard of care was breached. And then they write what they write. And I don't recall what it was in this case. It's typically they were put through a surgery that was medically unnecessary. He exaggerated the x-ray findings and radiologic and imaging studies in order to convince them to have a surgery that was not medically necessary. The surgery caused them more injury than they would have had they not had the surgery. That's the typical kind of paragraph they write. A few of the cases they write, the doctor breached the standard of care applicable to a like or similar practitioner.
Counsel,
They do write what the
Mr.
negligence
Chapman, you have a
is.
little more than a minute left.
Okay, and counsel, before your time runs up, quick question, because this wasn't really flushed out in in the briefing, but what evidence did Dr. Wilkie present to support the 18,000 in future medical for Mr. Graybow?
What he presented was based upon the previous expenses related to his pain management and care, plus Dr. Wilkie's own charges for handling patients on a go-forward basis for this type of care and the industry standard for this type of care. It's from his experience.
But did he provide any numbers, like any anything attached to it to actually say how much he expected the future cost to be?
He always testifies to an amount. I don't recall in this case what the record said as to the specific amount. And that amount varies depending on whether there's going to be a future surgery or whether there's going to be continued pain management, both, or door number 3, something else.
But we would need a number, or the jury would need a number to make that determination. Would you agree?
Well, I would agree that that they have to make the determination that whatever future damage they believe will occur must be reasonably certain to occur. They can extrapolate that by looking at the costs of previous medical management to determine what the cost is in dollars from those medical records. They have a complete set of medical records that describes every type of procedure. They have a complete set of records from the pain management doctors. Dr. Wilkie opines that pain management will be similar. Like I said, he usually gives a number, but if it's going to be similar, they can look at the similar bills for the pain management that already exists in the record.
Okay, your time is up if you'd like to wrap up.
Thank you. That's all I have. I just believe the case.
Okay, Mr. Herzig, I'm going to give you an extra minute since Mr. Statman got an extra minute.
Okay, thank you, Your Honor. Just to clear something up, I don't want to speculate about whether captain of the ship is an OJI. I don't have that answer before me. Mr. Statman asked about comparative negligence. Like I said at the beginning, we stand on our briefs on most of these issues. We don't think we need a discussion about that. We think there should have been a comparative negligence instruction, but just because I didn't mention it in argument doesn't mean we're waiving it. The flip side of that, of course, is if you don't mention it in your brief, you have absolutely waived the argument. We do have concerns that this court is getting very liberal with those rules in these cases, and so we think it would be important where they make no effort to help the court understand their argument on captain of the ship or superseding cause. It's not the court's job to do appellee's job for it, and we think that's an important message to send across all cases that come before this court, and we can't have separate rules for just these cases. Just to clarify, I said very clearly we haven't seen a case outside of Hamilton County. Of course, the Southern District of Ohio is in Hamilton County. The Atwood cases are Durrani cases. The Atwood cases have not yet gone to appeal, despite our efforts to try and get it there, because when you have all these multiple plaintiff cases, they get very complicated and they sit with judges for a long time. So Atwood has not been approved by any appeals court. Interestingly, the lawyer in Sayuta, the only other case we can find, becomes the judge in Atwood. There's a very narrow line of cases here for this court to look back to. Look, my colleague points out something important, which is that yes, we get whipsawed here. If the punitive damages are the same, and we argue that that is one way for the court to understand that there is significant prejudice here, we're told that's not good enough. And if the punitive damages are different, we're told that's not good enough either. We get hit on both. You can do that with all of these things and put us on both sides of the coin. The main point here is that and I'll just go back to your concurrence, Judge Bach. You laid out the actual law as it is applied throughout Ohio and everywhere else that we can find, that these cases should not be tried together, whether it's informed consent or not. In fact, as you point out, Judge, it's all the more important when it's about what the patient knew and when they knew it and what they heard and who they heard it from. And when you pile those things on together, those inferences are actually all the more prejudicial. Because it's just the testimony of the plaintiff or the hearsay of Dr. Tayeb about what he thinks he's been told about what Dr. Durrani has said to other people. And so we think it's all the more important to separate these cases. How do you know that there's prejudice here? Mr. Grayboe it was an 8 out of 10 when he went to see Dr. Durrani. After his surgery, he told his physical therapist he was a 0 to a 2 out of 10. And yet a jury still decides that this is an improper surgery when it in fact improved the condition of the patient. Maybe that happens in a single trial. It's much more likely to happen when you're piling on 3 trials, including one where there is this artery nick. To clarify that too, yes, you've had a few cases where other surgeons did the surgery. There were juries that because of other errors that had been made with regard to the absent defendant instruction and some other things that this court has fixed over time, where a jury found that Dr. Durrani was liable for a surgery that he did not perform, and this court fixed that. So Judge Nestor is exactly right when he says that, of course, every doctor has their own duty of care in the operating room, and we should have been able to present that question to a jury through jury instructions.
Mr. Herzig?
Yes.
Does the narrative of the jury interrogatory ever change? Like Mr. Statman would have us believe, and perhaps in this case it says basically that they should have never had the surgery. Is there ever any mention of these other surgeries? For example, in the Schultz case, does the narrative indicate like that was something that caused damages, the artery problem, the nick problem, the vein problem, whatever it was?
I don't know if that was specified here, but yes, these things are getting very standardized across cases. And no, we asked for a specific instruction on that issue, and it wasn't given. Just to talk briefly about, my colleague talks a lot about how long these cases have taken. These cases started in 2014 in Butler County.
Just real quick, Mr. Herzig, you have about a minute. If you want to spend it on what you're going to say, that's fine, or you can move on to something else.
I'm looking down my list. Unless there are questions, what I want to wrap up on is what appellees tell you, and we recounted in our briefs over and over again the history of these cases, is that the prejudice is the point. They have tried over the years, after losing 4 out of the first 5 cases in Butler County, to get them all tried together here in Hamilton County. That created years of collateral litigation, which then comes back to separate cases. But the last thing they want are individual cases, because the prejudice is the point. And we've quoted that over and over again in our briefs. And the reasoning of the trial court is nothing more than economy. And that's not sufficient either. So I don't think the work has been done below that gives this court the ability to fix or rescue it. This court needs to say, we need specific findings about why these cases are similar and won't unfairly prejudice the defendant. And where we have that, we then—
Mr. Herzig, your time is up if you'd like to wrap up.
We then can have appeals with a real factual basis and determine on a case-by-case basis where consolidation maybe is appropriate sometimes, and we think often isn't. Thank your honors for the time today.
All right, thank you both. Your case has now been submitted. We'll issue a timely decision. Have a good day. Stay safe out on the roads if you're driving.
Thank you.
Thank you.